everyone. Good afternoon, and welcome to this last lecture for 2025 of the lecture series Phish and Chips lunchtime lecture series on cybersecurity. I'm Dr. Neovavula. I'm an associate professor and chair in cyber policy at the Faculty of Law, Economics and Finance of the University of Luxembourg. And it is a great pleasure to welcome you to this last lecture, where we're joined by Dr. Giorgio Chiara, who is an assistant professor at the University of Bologna, and actually an alumnus of the University of Luxembourg, where he partly completed his PhD research in 2023, funded by Marie Curie Actions and supervised by our very own Professor Mark Cole. Pier Giorgio's work is very much interrelated with what we do here within the chair in cyber policy, because he's an expert on cybersecurity law. His research interests include the regulation of new technologies and these impact of normative impact of the digital revolution. So we are very, very happy and delighted to have him here today, where he's going to talk about one of the key legal instruments in EU cybersecurity law, which is the Cyber Resilience Act. And the Cyber Resilience Act is very interesting because it is a legal instrument that is based on internal market, and the regulatory approach that it takes is one very much related to the internal market goals, such as to have a holistic approach or to have an approach which is risk-based. But at the same time, Pier Giorgio in his research has noticed that there is also a fundamental rights approach, which is quite new for this piece of legislation and for EU cybersecurity law. And therefore, without further ado, I'll give the floor to Pier Giorgio for his lectures. Thank you very much for coming.
Thank you very much, Niovi, for the invitation. If I may start with the presentation. So this is the outline of what I'd like to talk about today. I'm trying to keep it brief so we can have some time for a Q&A session. Before delving into the pillars, so to speak, of the regulation, I'd like to say a few words about the background of the CRA, right? And then we'll try to problematize, so to speak, an aspect Niovi already introduced, namely whether and to what extent the CRA eventually protects fundamental rights as claimed by the Commission in the proposal. So, in 2020, the Commission published the third cybersecurity strategy, and in the first area of innovation of the strategy, the Commission pointed out the possibility to introduce new horizontal rules to improve the cybersecurity of all digital products and associated services placed on the internal market. The horizontal rules I just mentioned would eventually, in the ideas of the Commission, complement the measures addressing product cybersecurity, as the Commission, from the adoption of the second cybersecurity strategy in 2017 and the implementation of the Cybersecurity Act in 2019, adopted much more vertical, so to speak, regulatory approach, right? It is including or revising pieces of legislation in the new legislative framework by introducing mandatory essential cybersecurity requirements. We can witness this by looking at the Radio Equipment Directive from 2015, whereas the delegated act was implemented in 2022, specifying particular categories of equipment falling in the scope of the directive to which cybersecurity requirements already included in the directive would be applicable, or the revision altogether of these two pieces of legislation into new regulation that would include cybersecurity requirements that were missing previous directives. So, coming now to the proposal, so eventually the idea of the Commission and the strategy made it through, and in September 2022, the Commission proposed the Cyber Resilience Act. Basically, the problem at the core of the Cyber Resilience Act proposal was that most hardware and software products were not covered by EU law vis-à-vis their cybersecurity in a comprehensive. Therefore, the other, let's say, the other side of the problem was that other software products or products with digital elements, broadly speaking, were subject to successful attacks due to two causes. The first one was that the level of cybersecurity of these products was very low, affected by vulnerabilities that were not patched by producers of the products. And the second cause was that the Commission found that users could not understand or access relevant cybersecurity information relating to these products. So the proposal aims to ensure manufacturers improve the security products, ensure a clear and cybersecurity framework, including these rules parallel with the revision process of directive, enhance the transparency of properties of product with digital elements, enable businesses and consumers to use products with digital elements in a secure way. So I put forward this, let's say, interpretative framework. I would say that the CRA builds on three regulatory approaches: a horizontal framework, a risk-based approach, and a product safety approach. Of course, the combination of these approaches finds an organic application in the regulation. Clearly separating these foundational choices and their operational scope within the text of the regulation would be artificial and, in any case, of little practical use when it comes to implementing the various provisions, right? Nevertheless, I reckon that applying this interpretative framework can be helpful in illustrating the regulation's technically and legally complex mechanisms. So, the horizontal framework, the Commission, as we mentioned before, shifted from a vertical approach to a horizontal approach, and that opted to ensure legal certainty and avoid further market fragmentation by setting out baseline cybersecurity requirements for all products with digital elements. These requirements, we will delve into those later on, are object-oriented and technology neutral, and indeed apply to all so-called. Question now would be, what's a PD? What's a product with digital element? Products with digital elements are defined as any piece of hardware and software, including the software in the absence of which the product cannot perform one of its functions, remote data processing solution. So, in the hardware category, we can find smartphones, laptops, smart appliances, network equipment, whereas in software, including non-embedded software, we find operating systems, games, word processing, mobile apps, and so on. Remote data processing solution that might be trickier. So Examples of this, and I show you again the definition perhaps, the software in the absence of which the product cannot perform one of the functions. So might be, for example, a mobile application that provides access to an application programming interface, API, or to a database provided by means of a service developed by the manufacturer. So before that, I'd like to talk also about exclusion. Not all PDs fall within the scope of the regulation, right? For example, products with digital elements are already covered in sectoral legislation that set forth cybersecurity requirements that are deemed by the legislator at least equivalent to those of the Cyber Resilience Act, are excluded from the scope of the regulation. For example, medical devices, in vitro medical devices, motor equipment, AV equipment. Also, products that are modified or developed exclusively for defense of national security purposes are excluded from the scope of the regulation. An interesting carve-out is also regards FOSS, namely free and open source software. It was a huge debate during the trilogue negotiations. So free and open source software falls within the scope of the regulation insofar as it is monetized. It is, let's say, put into use or made available in the market within, of course, commercial activity. FOSS that is not monetized falls outside the scope of the regulation as services. Services as such falls outside of the scope of the CRA because they're already covered by the NIST directive. However, this edge, the remote data processing solution can involve software, but requires that these, for example, cloud solutions have a strong link, to the product developed by a manufacturer. So the second regulatory approach is the product safety approach. We do know already from the AI Act, for example. So I will not spend time delving into the different pillars of the NLF because we don't have time for that. I will start simply by saying that the first obligation, relevant economic operators have to, and by economic operators, here I will just discuss the obligations of manufacturers. It is the king, so to speak, of the economic operators in the context of NLF and the CRA specifically, even though the CRA sets obligations for all the operators, all the relevant operators in the value chain of PDEs, such as importers, distributors, authorized representatives, and free and open source software developers, that is, the stewards. Manufacturers of PDE have the lion's share of obligations as envisaged by the CRA. The whole compliance process starts with the assessment of the cybersecurity risks associated with the product, and we are now in the design. These cybersecurity risk assessment must inform all the phases. As similar to what's happening in the AA Act, the approach here is a life cycle, which makes a lot of sense in the cybersecurity domain. Then the core principle, say, of the NLF is that you manufacturer, you can put the product available in the market if the product itself respects essential requirements, right? So the manufacturers has to make sure that the product respects the two sets of essential cybersecurity requirements set out in Annex 1 of the CRA, and they are high-level requirements, as is the case of all essential requirements in NLF legislation, but a lot. So, for example, I can read a few of them, like in Part 1, that is cybersecurity essential requirements relating to products characteristic. So it says at letter A that products with digital elements shall be made available on the market without known exploitable vulnerabilities. That's it. Very level, very abstract. But the catch here, how a manufacturer can actually enforce this, work with this, you have to look into harmonized technical standards, for example. And I know that Irene Camara came here in the last episode. Huh?
Yes.
So you know already what these standards are. They provide conformity if applied, a presumption of conformity actually, if applied to the requirements, the central requirements. Right? The second part of Annex 1 covers essential requirements relating to vulnerability handling, which is a huge important part of the CRA, reflecting the importance of vulnerability handling in cybersecurity. And then we have a bunch of different obligations manufacturers have to respect. There is an article specifically, Article 13 in the regulation, that has the rubric as manufacturer's obligation, that has 25 articles. So that's a lot. For example, 7 of these 25 relates to information obligations that manufacturer has to provide to users, or due diligence obligation. So, for example, when a manufacturer integrate a component sourced by third party, which is the case in nowadays very intricate, complex supply chains, the manufacturer has to make sure that the component to be integrated does not impact the cybersecurity of the product with digital elements the manufacturer eventually make available on the market. And relating to that, if the manufacturer finds a vulnerability in a component sourced by third parties, first, it has to notify the vulnerability to the entity responsible for that component, and secondly, must address the vulnerability. And if in addressing the vulnerability, the manufacturer develops a patch, a so-called patch, it must share the patch with the entity responsible for the component. This illustrates also how the CRA eventually operationalizes a cooperative approach, which is, let's say, good practice in cybersecurity, reflecting also another principle, that is information sharing. Many other obligations. Then there is the placing on the market, and afterwards, because as we said, the CRA adopts a life cycle approach, the obligations of this for manufacturers do not end with the making available of product on the market. For example, they do have separate duty to report, for example, of any exploited vulnerability in products and severe incidents having an impact on the security of the product with digital elements. Interestingly, if you look at the procedure envisaged by the NIST, the report of duties, during the CRA, the manufacturer has to notify to 2 actors simultaneously via a single platform that are the competent CERT and ELISA. The time frame, right, is aligned with the one of the coming now to the risk-based approach. So product digital elements are clustered, so to speak, into different categories based on the risk rating, cybersecurity. We do have a default category. In the estimates of the Commission, they're going to be 90% of the products regulated by the CRA. We do have important PDD. These products whose core functionality is listed in Annex 3 of the regulation. And for the Commission, in order to modify this category, we have to look whether PDD with a higher exposure to vulnerabilities, higher related functionality, or the performance of a function area, risk aspects. And then on the third category is critical PDDs for functionality is listed in Annex 4. Basically, we must to expect the two criteria of important PDDs plus these products. Well, they must entail a critical dependency relationship with these two essential entities, and the incident and vulnerability must be seen as disruption, critical supply chain, in order to consider with PE. These classification has effects not as in the case of the AAF, for example, in terms of which requirements to follow, because all these products must respect all the list of essential cybersecurity requirements we discussed about before, laid down in Annex 1. So the impact of this classification is reflected in the different conformity assessment procedure manufacturer must follow to assess whether the product respects the requirements, right? For example, regarding default, manufacturers can choose between self-assessment or third-party assessment, whereas growing cybersecurity is got important products and critical products. Manufacturers are more constrained, so to speak. And for example, with regard to critical products, if delegated acts exist from the Commission, manufacturers have to adopt the European Cybersecurity Certification Scheme relating to the particular category of products and digital elements. If these schemes do not exist, so there is a delegated act introducing this obligation, then they can opt for different procedures falling within the category of third-party assessment. So, coming now to our problematization of the day, the explanatory memorandum to the proposal claimed that the CRA would eventually uphold fundamental rights. If the neighbor, so to speak, regulation of the CRA, between the AAM, more explicitly combines a rights-based approach with the product safety approach, the CRA, prima facie, you can say, integrates just risk-based approach and the product safety approach. And so we will try now to answer this question: to what extent the CRA enhances protection from the So besides indirect, say, rights protection, that is, if we make products with digital elements more secure, more cyber secure, we will have fewer fundamental rights infringements. For example, let's think about personal data protection, right? Or privacy. Then, if we look closer into different CRA's obligations, CRA's provisions, manufacturers' obligation and essential requirements do not include mechanisms ensuring that these products respect fundamental rights. The AA Act was way different than this. As in the latter, the only references to fundamental rights relate to enforcement procedure. So, in a nutshell, we do have in the CRA private enforcement. So, market surveillance authorities have an obligation to inform consumers where to submit complaints indicating non-compliance with the CRA. But at the same time, the CRA does not foresee an autonomous individual right for consumers to lodge a complaint to authorities. But then we do have different level enforcement. So authorities evaluate. This is standard NLF procedure, right? So authorities evaluate the products regarding its compliance with the text, with the regulation. If they, authorities, have a sufficient reason to consider that the product presents a significant cybersecurity risk, then they start an proper investigation that eventually including a tweak the prescription of corrective or restrictive measures, for example, recalling a product from the market. Very harsh. Interestingly, the Commission is empowered to activate these procedures, the enforcement procedure, by informing the relevant authorities, or the competent authority, that a PD is likely not complying with the CRA requirements. To do so, there must be like three conditions. The first one being the relevant authority, competent authority, does not take effective measures. The Commission has reason to consider that the product remains non-compliant. And third, in cases that justify an immediate intervention to preserve the proper function of the internal market. Now, if we look again closer to specific articles related to this public procedure, Article 57 says that although compliant with the draft, so it's not this case, non-compliant products with the text of the legislation. Although compliant with the regulation, a product can nonetheless pose significant cybersecurity risk, or other risks such as to compliance with obligations under Union or member states law intended to protect fundamental rights. So the process here is somewhat similar to the one we saw before. Should an authority conclude after investigation that that's the case, these products, even if compliant with the regulation, present a risk to the compliance with obligations, they can enforce the same restrictive or corrective measures they can have towards non-compliant PD. And similarly, the Commission can take over from the national competent authorities if exceptional circumstances justify an immediate intervention to preserve the proper functioning of the market. No effective measures have been taken by relevant authorities, and as sufficient reason to consider that the PDE will present, continue to present the risk. So, from a procedural standpoint, interestingly, the CRA is very concise. For example, we do not know how much time has passed the mission notification to relevant national authorities and their inaction before the Commission can actually take up. Also, what are these exceptional circumstances justifying the immediate intervention of the Commission? There's one recital of the CRA, it's just one reference to seemingly, I say, less than anticipation, that is that is used in the key sector by instrumentalities contain known vulnerabilities supported by malicious actors, right? Also, it's not unreasonable to imagine that law enforcement at national level might risk becoming the rule rather than exception if we look at the broad scope of the CRA, especially at the very beginning of the implementation of the regulation. So this procedural capacity is considered power in the hands of the Commission. On the substantive side, the problem, so risk, as we saw, is not the fundamental rights per se, but rather to the compliance with obligations intended to protect fundamental rights. So, in the first scenario, which is more the scenario of the AA Act, the emphasis is on the violation of the essence of the right, right? So the authority, the proceeding authority, might be the National Authority of the Commission, has to present an expert-based, contextual, normative assessment. It is the, for example, FRIA, fundamental rights assessment, determine whether a product contains a risk to specific. In the second case, the risk is somewhat more specific. Compliance with the second level model implementing a fundamental right. For example, GDPR. So the authority here has to verify whether a specific key complies with a set of obligations that is implement the fundamental rights intended to protect. So the outcome of such assessment, first, might be binary. An obligation is either respected or violated. No? But such a non-flexible understanding of compliance seems to be at odds with the rationale, the very rationale of risk, which is immediately scalable graph. Especially if we look at the experience in data protection. So I argue that even in this case, a compliance factor is normative, qualitative, context-based, expert-based evaluations, depending on the specific obligation that is scrutinized. So if we recall the questions we had before, so now Article 57 of the CRA really enhance compliance, existing EU legislation safeguarding protect rights. We might answer in the affirmative, as for example, data protection authority. We look at the interplay between the GDPR and the CRA. Do not have the enforcement powers of market surveillance authorities under the NLF, and the case of the CRA is the same. Even though we do have different powers which might have a similar impact. For example, the ban on the process. As a result of the interplay between the GDPR and the CRA, where are products with digital elements, although compliant with the CRA regulation, might pose a risk to the compliance of GDPR obligation. National authorities of the Commission will be able to take the same measures that the authority can enforce vis-à-vis non-compliant products. So, to conclude, market authorities do not seem well suited to carry out this value-based, normative, context-dependent assessment. For example, if we compare the expertise found in the authorities to the ones that we found in data protection authorities, also in light of chronic understaffing and underfunding, well documented in Europe, and coupled with an unclear and obscure opaque procedure, it is likely that an authority's lack of readiness to initiate an enforcement procedure may eventually give ground to the Commission to take these power, right? And against the backdrop of the increasing relevance of non-technical factors in cybersecurity to determine the significance of a risk, the underlying risk of these organizations is to weaponize fundamental rights to eventually achieve political and geopolitical goals. So the presentation ends here. I will leave you with actually a project we are nearly with my team. It is a legal design guide to the EU Cyber Resilience Act. This interactive PDF will eventually be released in by the end of December. It's going to be open access and it's going to be in English. It aims to provide operational guidance for all the stakeholders involved in the CRA, mainly manufacturers, to lower eventually the high technical legal complexity of the regulation. And to do so, we adopted this legal design approach. Not only with fancy drawings and fancy schemes stuff, but we did a process of kind of translating the more complex provisions, restructuring the more complex provision in a way that makes sense to the operators to integrate those in their compliance process. Right. So that's it from my side. Thank you for the attention, and I look forward to any questions.
Thank you so much, Giorgio. That was really enlightening. I've read the relevant article. I teach that to the students who follow cyber policy in the Master in Space Communication and Media Law, and the Master at SMT on Cybersecurity and Cyber Defense, although a little bit less legal for them. So it's extremely interesting, and I would like to spark the discussion with perhaps a little bit of a provocative comment. To what extent do you see that in the cybersecurity domain, then the Commission becomes like a guardian of fundamental rights, and how this is changing a bit the paradigm of what the Commission can or cannot do? And second, whether the guide also has some guidance for the Commission as to when to intervene, or is it simply more for them on the manufacturer side?
Okay, so thank you. With regard to the first part of the question, I would say that the Commission kind of followed a consolidated pattern. So if we look at market regulation with the VSA and the DMA, the Commission retained significant power. So from my perspective, it just makes sense that even in other fields, regulatory fields such as cybersecurity, given the stake, the Commission would eventually decide to centralize, so to speak, the governance model. Even though this particular domain, that is cybersecurity, as we discussed a lot, has its own specificities, as an important dimension of cybersecurity relates to national security, which is pursuant to Article 4, Paragraph 2 of the Treaty of the EU, is a sole competence of member states. So we might observe play, so-called what Bygrave calls turf wars between institutions, not only the Commission and member states, when it comes to regulate the very same operational perimeter. The former pivots on market ground, European security, say, competence, whereas the latter regulate topic and the actors
building on their national security prerogative. Coming to the guide, well, yes, technically, like as in the second point, it might be interesting not only to economic operators directly impacted by the regulation, by the CRA, but also in general to the broad, let's say, audience that must, work with the regulation. For example, IT guys and legal guys. Why not the policymakers? Also, from a technical, more strictly technical viewpoint, we did a lot of work on the standards part. So we did a mapping of existing relevant international or European standards that might be used eventually by SEN and SENELEC as a basis for the upcoming harmonized technical standards that will provide presumption of conformity with essential security requirements, so that for the time being, manufacturers can have somewhat at least a glimpse of, how can eventually they can operationalize the requirements. So yeah.
Good. I have other questions, but I don't want to monopolize the discussion. So I'll open the floor to the public. If you have any comments, any questions, any thoughts.
Hi, I'm Carsten Ulrich. I work at the university as well. I have a question on the essential requirements. I think you said that
Yes.
they're not really, there was a slide that you said that essential requirements are not really helping in fundamental rights assessments for the products. Yeah, thanks. But maybe you can explain that, because in my view, essential requirements are really the core of what I call the new approach, new legislative framework, which goes back into the 80s, the famous rulings, all that. So they were actually put up or drawn up to harmonize legitimate concerns on member state level on public interest criteria and fundamental rights. And so their very point, apart from maybe ensuring interoperability, is to actually protect or take account of fundamental rights and also public interests. So I just want to understand that context when you say that the legislation doesn't really, the essential requirements don't really address the fundamental rights issue. And the second question is, you're addressing legal guidance, which I think is very helpful to a lot of economic actors and other participants. What about the market surveillance authorities? Because they are, from my experience, the most stretched and the most challenged by all these assessments, and there will be lots of market surveillance authorities in smaller member states who are getting slapped this kind of duties on now, and they probably need guidance too, I think.
Yeah, thank you, Karsten, for these questions. So coming to the first one, indeed, indirectly, the CRA upholds fundamental rights as if we have more secure products, because these products are in conformity with the long bunch of essential cybersecurity requirements in Annex 1, then it's likely that we will have less incidents, less vulnerabilities. On the other hand, I said that the requirements in Annex 1 of the CRA does not directly mention fundamental rights, as opposed, for example, to AA Act. In the AA Act, we do have, for example, explicit mentioning of fundamental rights protection, or rather risks to fundamental rights, even in essential requirements. If we look, for example, at Article 9. And of course, essential requirements under the AI Act regime will only for a specific category of AA system, high risk AI system. Whereas in the context of the CRA, this risk taxonomy does not add up, as all the problems with digital elements under the scope of the regulation must eventually conform to the whole list of the circular bond. So that's it. Then, as you said, from a direct, relation between not rather the requirements per se, but the enforcement procedure of the CRA and fundamental rights protection, we do have some challenges, some limitations, and possibly even opportunities. And coming to the second question, it's interesting. So perhaps I have it on the slide. Yeah, maybe. So at the moment, so we intend the guide to be as a living instrument. So after the release, we will still take care of it and eventually implement. But even after the feedbacks, of course. But for now, we only focus on a specific aspect of the regulation. So what was more urgent, let's say, for economic operators to grasp, it's to lower the complexity of the regulation. For example, we covered what finding independent is an aspect of it, but the scope of it, which is, if you recall, not super clear. It's not crystal clear, how to draw boundaries between which PDD are eventually within the scope, which are not. Not mentioning, for example, the outside exclusion, which is, out of discussion, but for example, services and remote data processing solutions, that's tricky. So scope is what we focus on, of course, all the obligation part, all the essential requirements part, the standardization part, but we left out for the moment. Maybe it's something that we are actually discussing now. We include the chapter 4, if I'm not mistaken. It is all the MSA say aspects of notifying bodies, the interplay between national authorities and notified bodies, all these procedural aspects of NLF enforcement. So at the moment, it's not there, but we're actually discussing to complete, so to speak, the coverage of the regulation, even with this with the chapter. Even though it's a design and simplification exercise, and still without that particular aspect of the regulation in the guide, it is substantial. Now we have 80 pages or so, so it's a very lengthy PDF already. But we do hope, nonetheless, that can actually provide meaningful guidance and help those that have to translate these intricate and complex mechanisms into practice.
Is there another question?
Yes.
Thank you. Still remain clear for me up to when the producer is obliged this obligation on ensuring that the product is in conformity with the regulation of CRA, and also in case it's not, so maybe I don't know. We will explain with the obligation to make remedies, and then this is a cost.
Yes.
To pay for this.
Yes. I didn't mention. Thank you for the question. I didn't say anything about that. Is about the super period, right? So, manufacturers have different sort of obligation for a certain time. That is the so-called super period. So, for example, the general rule is that they have to provide security updates and they're liable for relevant application for 5 years. But then there is the that support period might be even, let's say, shorter, then the manufacturer has to justify why the support period is shorter than the general golden 5-year rule. Other obligations have longer, longer periods of assistance. For example, with regard to security updates for a modified version of a software, let's say, manufacturer has to make sure that these security update for the modified version rests available for 10 years after the release. Or if it's longer, the time the expected life of the product is so. So the support period and maintenance phase timeline is crucial for all the economic operators because indeed it's a cost. And also regarding to that, another obligation I find particularly interesting, let's say, is paragraph 10, article 13 of the CRA, where CRA states that manufacturer that eventually release new version, a modified version of a software product, can provide security updates only for the modified new version of the software and not for other past old versions. Provided that the users of software can have the last version of the software for free. So they can actually provide security updates only for the last version if the users of the previous version can access the last one, which is interesting. Yeah, thank you.
Are there any other questions, comments? Yes, please.
Thank you for the presentation. I wanted to ask you about the reporting deadline for incidents in comparison to NIS2.
Yes.
Because
That was one of the things that I wanted to say. Yes. Please, I'm so happy someone mentioned that as well.
Okay, so I said that the CRA aligns with the NIS2 time frame in that it's from a procedural viewpoint, it's a tripartite phase of the. So if we take, for example, several severe incidents having an impact once a manufacturer comes to know that a severe incident happened, has 24 hours for an early warning, as it is, 72 hours to complete, the notification with a proper notification, as in the list, and as in the list, 1 month after notification to deliver a final report to the two references here, specifying a bunch of information. If we look instead at the vulnerabilities, the first phases aligns. So 24 hours, 72 hours for the notification, and then the so-called final report must be handled in 14 days, not longer. I assume because of the say security risks made by sure. And in the this let's say final report, for example, they must acknowledge whether malicious actors exploit the vulnerability, what, and eventually if mitigation actions, for example, by building a patch, have already been let's say carried out. So yeah, the two timelines aligns in the second instance, perfectly equals to the first one, most of it. And if we look at what's happening with digital omnibus package, I mean, the single entry point, I think it's probably the digital omnibus, will be built eventually by ELISA. Looking at the experience of the CRA, this is the single platform through which manufacturers must apply these instruments and vulnerabilities to users and so the interplay between these legal acts, the cyber and data protection field is eventually strong.
Are there any other questions, comments, thoughts? Yes, please. Sure, we have time.
I just wonder about the standards based on which manufacturer make these self-declaration, CE marking.
Yeah.
Are there, for cybersecurity, I'm not an expert on the subject, but I wonder whether the standards are specific enough for reduce, let's say, the complaint, or there's still a lot of margin of interpretation of it.
So, if the question regards the harmonized technical standards that eventually are being drafted by CNIL, the European Standardization Organization, on the basis of the mandate of the Commission to cover the relevant essential cybersecurity requirements of the CRA, we still don't know. Because they are not out yet. The first batches of these harmonized standards are out for, let's say, inputs, but the draft of this and not the complete ones. So, but as a general rule, as I'm pretty sure Kamara would say last time, these harmonized technical standards build, possible, if available, build on existing international standards. So there is a strong alignment between European harmonized standards and ISO body of standardization. I couldn't actually enter into that too, but there are. Well, ENISA, for example, in 2023 and 2024, published two interesting reports on a mapping of existing international and European standards taking these requirements, CRA requirements. And the outcome was that coverage of the requirements was not perfect, of course, and the standards would take those. The different standards would take a specific aspect maybe of specific requirements, and not full of whole list of requirements. But there is already a good basis. If we look, for example, at the OWASP framework, or there is also a quite mature ETSI standard, the 303645. Other ISO IX. So there are already lots of instruments that eventually take comprehensively all the aspects of requirements of the CRA, and still it's still to be seen what will be the final form of the harmonized. Interestingly enough, as in the AI Act, also the CRA contemplates common specification by the Commission if harmonized technical standards are delayed. So these technical specifications, standards, but developed directly by the Commission. And also common specification around the presumption of conformity, so as the other relevant parts.
Thank you. You compared the survey with the AI Act and at some point in your presentation. And what do you think? Can you please share your thoughts about the main lessons that regulators can learn about their different approaches? I'm not sure if this fits you.
Thank you. Well, the expert on the AA Act is Marco, so maybe he can jump in the discussion. But as I mentioned before, both these two regulations share an important regulatory approach, which is a product safety approach, even though the AA Act hybridizes it more explicitly with fundamental rights or rights-based. So I think the main lessons that can be learned from one from each other are how eventually the implementation of these two regimes will be successful. I did not tell that even though the Cyber Resilience Act already entered into force, its application, as is the rule now, is delayed. So the reporting obligation started to be applicable in September 2026, whereas all the other obligations in provision, beside notifying bodies and markets based on authority certification, will be applicable from 11 December 2027. So there is still a huge window of time, and it makes sense because a lot of operators who think about this code and the obligations have to adapt to this new regime, and it's going to be costly. So I guess the implementation phase is the real test, and eventually how this will be rolled out. Thank you. And AMIS, the Digital Omnibus report.
Anything else? Anything we may come up with?
Hey, Peter Jorge, to come on this point of the differences between the AI Act and the CRE, one point where the learning can take place as a two-way street is in the way that risk is framed. Because go to that slide where you point out Articles 57. Mm-hmm. You mentioned that, okay, how do you frame the idea? It's framed in terms of the risk to the violation of union or member states law protecting, whereas the AI Act goes a bit stricter, a bit more directly as a risk to fundamental rights. But what does it mean, in your view, to have a risk of impacting the functioning of fundamental rights? Because risk, even the AI Act, the CRA, they both rely on the definition of risk being something that happens with a likelihood, and if that happens, then that will have a severity. How do we fit this broader, more abstract framing into something that we can say it's still some kind of risk governance?
Yeah, we should call Gian Claudio Malgeri also to participate in the discussion. I mean, it's the $1 million question, I reckon. Also, lots of stakeholders, players are interested in these as, for example, if they are under the free obligation, they might be sanctioned if they do not apply. Well, at the end of the day, so data protection, I guess, can teaches us a lot about this. If we look at the DPAs, on paper, the quality of the assessment is very high. specifically if you look at paragraph 7 letter C, if I'm not mistaken. So the benchmark should be the old catalog, right? Instead, because of many reasons, including practicality of the instrument itself, it results to like old PIA point 2, let's say. So I think that, and in the digital omnibus, this is also like a huge role, no? I think that eventually, even though on paper these laws require complex, expert-based, contextual, qualitative, and normative assessments, at the very end, we'll end up seeing standardized kind of cross-checking exercise so that operators can work without bothering these qualitative and complex assessments. So, yes.
Then I have a follow-up. So, that was a very interesting question, I thought. This is just a question because I don't actually know, but from my point of view, one of the first directives which applied this approach a bit and embedded protection in 2 products was the Radio Equipment Directive, which in 2014 came in force. Are there any learnings from the assessments of or from the enforcement, or from the work on assessing how that system worked in the Radio Equipment Directive for connected devices?
Mm-hmm. Yeah, very interesting question. So to follow up on that, the 2014 directive on radio equipment has at Article 3, paragraph 3, letter E, separate essential requirements that relate somewhat to cybersecurity. Why I say somewhat? Because only letter D is cybersecurity focused strictly sense. It is a requirement that radio equipment do not have to interfere or degrade network function. Whereas letter E relates to data protection, letter F fraud protection. So if we compare the letter E of the Radio Equipment Directive to the Annex 1 of the CRA, the assessment would be impacted because it's just 2 different words. But the essential, not essential, the harmonized technical standards developed under that regime, particularly after the Delegated Act of 2022, specifying which classes or categories of radio equipment to which these cyber requirements applicable can be actually and will be are being used by Senelec to develop and draft the relevant harmonized technical standards for this area. And once the CRA regime will eventually be applicable, there is a decision to make vis-a-vis radio equipment directive because there is a complete overlap. Perhaps the choice would be simply but it's still, I guess, in the room buttons. But yes, but to answer to the first part, I don't know actually about the proper implementation. It might be interesting to might share some light on some possible future implementation of this CRA.
Okay, then unless there are no other comments or queries, we'll end our discussion. here. As always, the lecture will be uploaded on the website of the chair. So if you have additional things that you want to look at, you will be able to find it there. We will continue with the lecture series in the next year. We already know that the ambassador on cybersecurity, Mr. Luke Dettenforth, has agreed to deliver one lecture, which will be advertised in due course. In the meantime, we thank Pier Giorgio for coming. And delivering such an interesting lecture on a topic which, on first sight, may seem technical, but actually has a lot of juice. Thank you very, very much. It was really interesting, and we hope you have nice holidays, and I will see you in our next events.